Welcome to the second in our Back to Basics series of webinars. This one is on due diligence, what is involved. My name is Robert Kelly from Stewart Title, and joined as always by Ian Quayle from IQ Legal Training. Ian, how are you doing?
I'm very well, Robert. I'm in sunny Chelmsford, so I'm all's well with the world. I'm always happy when I'm in Chelmsford. I don't know why, but there you go.
We don't understand you're in a car. You've got some high tech.
I am in a car. There's technology all around me, Robert. So who knows what could go wrong? We can send a man to the moon. We're thinking about traveling to Mars. I'm not so sure how good the internet connection is in sunny Chelmsford, but we shall see.
We shall see. We'll give it a go. Thank you all for joining us again today, and also thank you for your very kind words and feedback on the last session. For anyone that missed the first in the series of webinars, if you get in contact, we can send you a link to a recording and a copy of the slides. As always, Ian's produced some very detailed slides and notes, which are very useful for you to look at, and we are very happy for you to use the recordings and the notes as part of your training for your team. I know some people have mentioned this week already that they are going to use it for bringing new people into the conveyancing team. We're very happy for you to do that. Very quickly before we start, if you have any comments, please put them in the chat room, and Ian will endeavour to deal with those as we go through.
Yeah.
But then just a little bit to remind you about Stewart Title. We can't help you with onboarding of clients, but we can help you once you start doing due diligence and investigating title. Stewart Solution is an online platform, as you'll see here from the brief details, up to £20 million worth of cover available online for self-issue by you. 150 different risks on there. All of our policies have 10% inflation cover for the first 10 years. So that effectively means if you buy a policy for £500,000 today, at the end of 10 years, it's £1 million, which covers you against most inflationary cover. If you do need anything higher than that, you can always get in touch with the underwriting team to have the policy topped up. It's a very simple online process, literally 3 steps and less than 60 seconds to get a quote and a draft policy. We do have variable assumptions on there, so it does allow you to reflect the exact situation of your client's property, and you can cover up to 10 units. So if you have a developer who's building a small resi estate with 4 or 5 houses on it, that can be covered on one policy. And similarly, the sort of standard high street mixed use property with commercial on the ground floor, a couple of resi flats above, that can be covered on one policy there. Where matters can't be done online or where you need further assistance, our highly experienced underwriting team are always available to help you. One of the great things about Stewart Solution is it means you can deal with the more standard transactional problems yourself. That does mean that our underwriting team are freed up in order to help you with more complicated or high value problems. That can be done by an email to the underwriting team, or if you start a problem on Stewart Solution and find you need some extra help, you can switch it over to the underwriting team whilst you're there. And finally, as well as the series of webinars like this, we do run with Ian monthly residential and commercial property forums to enable people to share ideas, problems, experiences together, led by Ian, who'll talk about some recent cases, but very much it's an open forum for you to discuss. In addition to that, Stewart Title does do in-house training for law firms, for your conveyancing teams. We can structure that to reflect the sort of work you do, the problems you're facing. We can look at day-to-day problems that title insurance can help with, like restrictive covenants, easements, change of use. And we can also do sessions on the regulation of the rules, now part of the SA requirements. The SRA do require that all law firms have regular training on title insurance, so we can do that, and hopefully that includes some useful tips for your team. So if you move to the next slide, Ian. These are the contact details. If you're interested in looking at Stewart Solution, all you need to do is ask us for login details. You can then go in and have a look round. There's no obligation, and that we don't get any bank details, no other details for you. So you can just have a look there, and as and when you need it, use it. If you're interested in any of the other training or interested in some of the other products, there's the BD team address. And if you are interested in any of those webinar training inquiries, please get in contact with me. But that's enough from me, Ian. So over to you and due diligence.
Thank you, Robert. Yes, Robert mentioned the Residential Conveyancing Forum. Our next one is tomorrow. I was just looking at some of the topics we're going to be discussing. We're going to talk about artificial intelligence and residential conveyancing. Next thing to talk about is, as far as today is concerned, we're looking at due diligence, as Robert mentioned. But the important thing, and I think I want to explore today, is the fact that if you have any questions or queries about anything that I say, use the chat facility. So the chat facility is open. You're more than welcome to put any questions in there, and I'm happy to deal with them either as we progress or at the end of the presentation. As I always do with events such as this, I recommend websites. Do have a look at the following websites. Property Protocols and the Boundary Dispute Protocol is well worth a look at. If you're dealing with leasehold transactions, have a look at the Leasehold Advisory Service website. Have a look at the Leasehold Knowledge Partnership website. And if you're dealing with Building Safety Act related issues in residential conveyancing transactions, Tanfield Chambers and Falcon Chambers both have building safety hubs, Building Safety Act hubs, that are well worth a look at and well worth exploring. So what are we going to explore today? Due diligence. Due diligence involves a knowledge of process, a knowledge of best practice. It also involves, in my view, an ability to provide advice and where advice should be provided. So we're going to have a look at that. There's also a need to provide explanation with regard to what due diligence is and what it isn't. So they're the things that we're going to be exploring. How do we find our way around due diligence? Well, we first of all remember what we said last week when we're onboarding clients. We look at our retainer. In our retainer, we should be telling the clients what we're going to be looking at and explaining to the clients what we're not going to be looking at. The clients need to understand the scope of the work that we're doing. We're very good as lawyers at telling clients what we're going to do. We're not good at telling clients about the limitations relating to what we're not going to do. And we're also not very good at telling clients the problems associated with due diligence. So here I'm talking about being realistic with regard to what the conveyancing process involves. What does that actually mean? We'll have a deep dive into some of those issues as we progress during the course of the presentation. So with regard to due diligence, I think there's some important background issues that we need to address and to consider. One, we need to identify client objective. What's the client hoping to achieve with regard to this residential purpose? And you might think, Ian, that's obvious. It's a residential conveyancing transaction. They're buying a home for themselves and their family with the assistance of a mortgage from a traditional bank or building society. I needn't ask the client's objective. You do need to ask client's objective for two reasons. One, to tailor due diligence to enable that objective to be achieved. And two, to fulfill your duty to get to know your client, which is required by professional bodies. As a residential conveyancer, there's an expectation that you know your client, and in knowing your client, it's also important you need to know what your client hopes to achieve in instructing you. Remember what we said last week, there's no such thing as a collective client, so we need to identify individual clients' objectives. We can act for more than one client where there is a common purpose. In other words, where clients' objectives are the same. We need to be alive to the fact that there may be issues that mean we can't act, notably where our clients' objectives diverge or aren't aimed or aren't designed to achieve the same goal. We need to understand the availability of due diligence, what it is, and where we can, or what we need to do to get it, and how we deal with it, how it's reported to clients is important. It's all well and good performing due diligence and having a magnificent file or case management system with all the results of due diligence on there. That has to be transmitted to the client in a manner that the client can understand and appreciate. And we have to be aware of what we need to do with regard to advising clients. And there are some limitations relating to the advice that we give clients. Finally, it's all well and good talking about due diligence and getting the property purchased and getting the deal done, but we need to be careful about protecting ourselves and our firms in connection with avoiding claims and complaints and problems. So, bearing all that in mind, let's cut down to the chase now and look at what due diligence involves. It involves the undertaking of searches on the client's behalf. We need to explain the limitations relating to searches, and we need to explain the searches that we are going to undertake. Let's deal with that latter point first. I would advise clients that there are essential searches, local land charges search, inquiries of local authority, potentially additional inquiries of local authority, a drainage and water search, an environmental search and report, assuming that the drainage and water search does not include or cover environmental issues. I would put a climate change report as an essential search for the purposes of today. And I would then say there are necessary searches dependent on locality, dependent on transaction, dependent on client objective. So here I'm thinking about mining searches, radon searches, geological searches, Cheshire brine searches, whatever searches are appropriate given locality. Searches that are necessary due to proximity of railway would be a railway authority search, HS2 search, waterway search, rivers authority search, again dependent on location. As far as the searches that we undertake on the client's behalf, then essential searches, necessary searches. I would also then say to any residential client, there are other searches that I perhaps could undertake if you require me to do so. Are there any inquiries? Are there any further investigations that you would like me to make on your behalf with regard to the property? I used to be of the school of thought that I would tell a client, these are all the searches that my search provider can undertake. I'm conscious that that opens up a can of worms. So I'd rather say to the client, there are searches that are essential, there are searches that are necessary, there are searches that I haven't mentioned to you, but there may be an objective or a purpose behind your acquisition. Let me know about that, and I'll see if I think there are any other searches that might be prudent or appropriate. Once we've undertaken searches, we need to explain the limitations relating to searches. For example, a local land charges search is property specific and doesn't carry any form of priority. As far as those other searches are concerned, they could be out of date due to changes in circumstances and the provision of information to the search provider. As far as the searches are concerned, it may be necessary to refresh searches if there's a delay between the date the search is undertaken and the day we exchange contracts. And it may be necessary to refresh those searches again in circumstances where we're aware of information post-exchange but pre-completion. Once we get our search results in, it's not enough simply to give the client a copy of a search and say, read it. We go back to that slide where I talked about the provision of information and talked about the provision of explanation and where appropriate advice. So I think we need to explain to the client why we've done the search. We need to explain the limitations relating to the search and then what the search reveals. And there we have a choice as far as the search is concerned. Do we advise the client about all the entries? So we go through each and every entry relating to the search and tell the client about it? Or do we simply tell the client about adverse entries only? I think that's a matter of choice. What I would say here is our watchwords or ought to be, and our guiding light ought to be, are there any interests or issues or risks revealed by the search that could be materially adverse to the interest of the client? That's the test. If there is anything that's revealed that's materially adverse to the interest of the client, it should be disclosed. Where there are adverse entries, I think they need to be included in our report. It may be that we can simply annex the report to our, annex the search result to our report and let the client know about the fact that there are, of course, information shared in the search that isn't necessarily adverse, but which the client should know about. Alternatively, we go through the search point by point and include it in the report. I think that's overkill, and I think the safe thing to do and what would be best practice is indicating in any report adverse entries or anything that's materially adverse to the interest of the client, then draw to the client's attention that the report is in fact annexed at the rear, the search is annexed to the rear of the report, and there could be other issues or other information in there that could be of use or benefit to the client. Where there are adverse entries, I think we then need to take some further steps. If further investigation is required, we need to indicate that to the client. And we need to indicate to the client three choices. The client can either undertake the additional or further investigation themselves and report to us what they find, or they can ask us to do it, in which case we may have to consider expanding our retainer or advising the client that there are additional costs, or we may be able to indicate to the client that they can go to the source of the information, the search provider in this context, and ask the search provider for additional information or assistance or support. I think the important thing is in the report on title, where we've discovered an adverse entry, we should be advising the client that we've identified that adverse entry. The client has then told us what they would like to do with regard to further investigation, and then in the report on title, what that further investigation has generated and what conclusion or advice ought to be given as a consequence. So let me give you an example. Environmental search and report comes in, reveals land is contaminated. We say to the client, the search reveals that the land on which your property is situated or part of it is contaminated. The further investigation that could be undertaken, we could be asked to undertake further investigative work with regard to the report provider, or we could ask the local authority for information about their register relating to contaminated land, or we could make additional inquiries of the sellers and the seller's solicitors with regard to the contamination. The client could be advised as to the risk and could be persuaded or pointed towards the report provider for additional information relating to risk. That risk could be the risk of being required to decontaminate, the cost of decontamination, the limitations on marketability as a consequence of buying the property that is in part or is entirely contaminated. Or we could say to the client, you carry out your own investigations. The client could come back and say, I'm happy to go to the report provider to seek further information and guidance, in which case my report on title should refer to that fact, and we should be asking the client to report to us what that further advice or guidance involved, and perhaps include that in our report as well. Where the client says, I'm going to deal with the matter myself, again, I would be including in the report on title, we identified a risk, you explained to us that you are happy to investigate the matter yourself. We are concluding that you've concluded those investigations and you're happy to proceed unless you advise us to the contrary. I think that they're the steps and measures that we ought to take. I think they're the important things that we ought to do. I think just simply leaving it on the basis of here's the adverse entry, here's the risk, here's the issue is not enough. When we talk about advising clients in connection with due diligence, other than any due diligence that's undertaken with regard to title, we're indicating an issue or indicating to the client the existence of risk. And we're not determining the extent of that risk. Where due diligence is looking at the title and there's an issue or problem with the title, so there's a warning in the title that the title is in part a possessory title, or there's an issue with regard to a qualified title or a good leasehold title, then in our report, as a consequence of due diligence, we're required to explain to the client the risk associated with acquiring a title that is a possessory title or qualified title. So I think we need to explain those issues and make sure the client understands that and appreciates the risk or consequence of an imperfection with regard to the title. Again, the retainer needs to make sure that with regard to searches, we've got client objective, we are in the retainer explaining what due diligence involves and explaining to the client what we're going to be reporting on. The retainer identifies our contractual and tortious relationship with the client. Our report on title when due diligence has been concluded should cement that position and confirm what due diligence has generated. Again, remember what we said last time, if we're going above and beyond what we said we would do in the retainer, we need to expand the retainer in writing. We also need to think about charging the client for additional fees relating to additional work that's being undertaken. The retainer needs to deal with those issues. We talked about that last week, didn't we? As far as managing the retainer is concerned, again, we've spoken about retainer creep last time. And again, these 2 points on the slide, I think, are important. We're required in our report on title to proffer advice that's reasonably incidental to our task in hand, and reporting to our client on anything that might be materially adverse to the interests of the client. And again, our search results and the transmission of information relating to those search results should bear in mind those two key bullet points, bullet point 4 and bullet point 6 on the slide there. So what we now need to do is look at the revised TA6 and TA7 form and have a think about that, how that impacts on due diligence. With regard to the revised TA6 and the revised TA7 form, there is now more information that a seller should be producing to the buyer. And again, just as we did with searches, we've got to think about how, from a buyer's perspective, we're going to transmit information or relate information in the TA forms to our clients. Yet again, I think with regard to due diligence, it's not enough simply to give the client a copy of the TA6 form and the TA7 form or the TA10 form and say, read it. I think at the very least, we have to explain what this document is designed to do. We need to trawl the document to identify any adverse issues generated by the replies that are provided. We have to trawl the documentation to see if there are any replies that are inadequate and warrant further inquiry or further investigation. And we also need to check that there aren't any meaningless or badly drafted replies that, again, would warrant further investigation or further inquiry. So do we need to worry about the revised TA forms with regard to due diligence? I think we don't need to worry about them, but we need to be aware of what I would regard as a wholesale change in what the TA forms are designed to do and what a seller is obliged to provide as a consequence of the revision to the TA6 form and the TA7 form, and also the case law, Rosser and Pacifico and the Woodward Fisher case. So let's just go on a little further if we can. We already know that when we're acting for a seller, we've got to explain the potential dangers for misrepresentation and also the dangers of committing an offence under Section 2 of the Fraud Act if a deliberate lie is evidenced by a response to a question in a TA form. So we need to warn our seller about the potential vulnerability with regard to defective or erroneous replies. I think these days we also have to tell the seller client that in answering a question and behaving as a reasonable seller, there's an obligation on the seller to undertake reasonable inquiries before answering the questions. I think the seller also needs to know that a wide-ranging question would warrant a wide-ranging answer. I think the seller needs to understand the principles in Rosser against Pacifico, a case that was recently decided in the county court, that a seller needs to understand the status of the TA forms in the conveyancing process. A seller is probably in the best position of anyone in the conveyancing process to have information that would be relevant and useful to a buyer. And the idea of the TA forms is that the seller is sharing that information, warts and all. So a seller can't think to himself or herself, if I tell the buyer about that, that might discourage the buyer from proceeding. Or if I tell the seller that, the buyer might want a reduction in purchase price. The seller must understand that in answering the TA forms, he is sharing or she is sharing everything that he or she knows with regard to the property being sold, whether it is beneficial or detrimental to the sale proceeding. So bearing that in mind, if we're looking at due diligence and the TA forms, I think, again, we now need a change of emphasis. Our buyer client needs to understand what the TA forms are designed to do and what the seller should therefore be providing for us. The buyer should also be told that where the seller fails to fulfill its duties with regard to the provision of information or provides misleading information, then not only do we have a potential action for misrepresentation and a potential ability to report to the police for fraudulent misrepresentation and a breach of Section 2 of the Fraud Act 2006, We also need to understand that the revised TA6 has been amended so that the seller is aware of the need to provide material information, and as a consequence should be aware of a failure to comply with their duty to provide material information, leading to potential consequences and sanctions for breach of their duty. A buyer should always be told about the potential for suing for misrepresentation. Again, I think practicality should prevail, and the client should be told and warned that although there is the option to bring a claim for misrepresentation, the buyer may well not have the appetite or nor indeed the resources to bring such a claim. Which leads me or draws me back again to the material information point. It may be that a buyer properly advised with regard to the revised TA6 form would be better bringing an action for breach of duty on the part of the seller in failing to provide material information or providing material information that is defective. So the problem is that with regard to the revised TA6 and TA7 form, the seller is being asked to do more than he or she was as ever doing, and is also, I think, expressly or impliedly entitled to rely on advice and assistance provided by the seller's solicitors. That potentially leads the availability of a negligence claim against a seller's solicitor or conveyancer who's failed to comply with their duty in advising the seller as to how to deal with the revised TA6 and revised TA7 form. And I think that vulnerability to negligence has increased as a consequence of the revised TA6 form saying to the client, if you're not sure about how to answer this question, or if you need to undertake reasonable steps in order to answer it, consult or liaise with your solicitor. I think that adds an additional burden on the seller's solicitor that increases the potential for a negligence claim. Now, that is of no consequence as far as advising the buyer in connection with due diligence, but is something that I think should be referred to the buyer in any event. So acting for the seller we know about. I've given you some information in the slides and the notes. I'm not going to dwell on it this afternoon because we're talking about due diligence from the buyer. But the revised new TA6 form, which becomes live as of March next year, does impose additional duties and burdens on the seller to be more open with regard to the provision of information. It also highlights the fact that a misrepresentation claim could arise as a consequence of the seller's estate agent providing information that is misleading or defective, or a third party providing that information. So again, in our report on title, we need to be making sure that the buyer client is aware that where information has been produced to the buyer by the estate agent, perhaps even before we were instructed, or information produced by a third party on behalf of the seller, which the buyer is relying upon, that information must be correct. If it isn't, then again, an action will lie in misrepresentation. So I think as far as the due diligence is concerned with regard to the TA6, buyer should be told of the potential for bringing a claim against the seller in connection with incorrect or defective information or breaches of the Digital Marketing Competition and Consumers Act 2024 with regards to material information. But I think there's another practical point that we should be including in the report on title, namely, the buyer, I think, should use the questions in the TA forms as a checklist to satisfy themselves as to the information that's produced with regard to, sorry, I'm just getting rid of that, just apologies, bear with me. Providing information that will be meaningful to the buyer and useful to the buyer. And the buyer client needs to understand the more wide-ranging obligation on the seller relating to the provision of information. The next thing that I want to talk about is Section 2 of the Fraud Act 2006, and just to be aware that where the seller deliberately lies with regard to information in a TA form and the buyer is aware of it, the seller commits an offence under Section 2 of the Fraud Act. And theoretically, the buyer could seek compensation from the magistrates or Crown Court in the event of a conviction. Whether you'd include that in your report on title, I think, is a moot point. My view is you wouldn't include it, but you would be aware of the potential for such a claim in the event of a deliberate lie in the TA form or any other form of fraudulent or false misrepresentation. Okay, going on from that, if I can, I want to now share with you the warning signs in the TA6 form that I think generates the potential for greater liability in connection with the seller for misrepresentation. Sellers are told, answer the questions truthfully, completely, and as accurately as you can. You're expected to have a reasonable basis for the answers you give. Check the answers against information that's reasonably available to you. If you don't know an answer, you must say so. If you're unsure about an answer, ask your solicitor. So all of that, I think, increases the scope and the potential for a misrepresentation claim. For the buyer, again, and whether we include this in our retainer or in the report on title is a matter for you, but look at this. Again, I think this is important, and the buyer client needs to have a reminder of what the TA6 form, what the implications of the TA6 form are for the buyer. Buyers should tell their solicitor if they receive any information about the property other than information from the TA6 form and where particularly they wish to rely upon it. That information could be received in writing or in conversation, and the information could be from the seller or through the estate agent, solicitor, or a third party. So again, where the buyer has received information in this context and the buyer wants to rely on that information, the buyer should be disclosing that to you in acting on the buyer's behalf. And I think in your retainer, you should, and in the report on title, you should be drawing the client's attention to these sources of information. And in the report on title, having concluded due diligence, I'd be saying to the client, I advised you of the need to report to me any information that you received relevant to your purchase of the property, and either you have told me about things, or alternatively, despite my request to do so, you have not disclosed any information from third parties, and therefore I'm unable to advise on it. Again, I think we're just covering off the potential problem that the revised TA7 and revised TA6 is generating. So the TA6 questions include all of these issues. The things that I'm worried about are notices, communications, or discussions which affect the property. The seller could be telling us about those. And again, notices, communications, or discussions could reveal prescriptive rights, could reveal disputes, could reveal equitable interests, proprietary estoppel, types of claims or interests, all manner of different things that in our report on title we should be dealing with. The additional questions in the TA6 forms also include rights and informal arrangements and transactional issues. So we're going to get more information from the seller in the revised TA6. And again, as far as that information is concerned, it could have a bearing on the client's decision to proceed with their purchase, or could reveal issues that are materially adverse to the interests of the client, which will need to be shared with the client in our report on title. So again, I'm just flagging up here on this slide, rights and informal arrangements. The seller reveals them. I think as a lawyer acting on the part of the buyer, we need to scrutinize what the seller has said and explain to the client the legal consequences of anything that's disclosed. And again, as far as transactional issues, are there transactional issues that again require us to explain to the client the impact of those transactional issues on the client's decision to proceed, or indeed on the procedure or process that we're embarking upon. The TA6 also includes explanatory notes for the seller. Irregular boundaries. If you're unsure, contact your solicitors to insist in interpreting the boundaries. Again, if we're asked as a seller about that, problems, and if we're acting for a buyer, I think we need to warn clients that information from the seller or the seller's solicitor may not be sufficient to enable us to determine a legal boundary, or whether a physical boundary is also the legal boundary for the property. I think we need to be careful with that and warn clients about in our report on title about the problems and vagaries of identifying legal boundaries in the conveyancing process. Put simply, it is damn nigh impossible to identify a legal boundary in a conveyancing transaction in a standard due diligence exercise. What we're looking for is either evidence of what was intended when the boundary was created that enables us to clearly identify a legal boundary, or a determined boundary application having been made successfully to the land registry, or a boundary agreement that is in essence a demarcation agreement in accordance with the recent case of White against Alder, that means that that demarcation agreement is binding on the parties to the agreement and subsequent owners. That's the legal principle in White and Alder that means a demarcation or boundary agreement now can be binding on subsequent owners. Either a determined boundary application or a demarcation or boundary agreement should be noted on the title of the property we are acquiring and the neighbouring title. The TA6 explanatory notes also asks the seller to speak to your solicitor if you're not sure about information relating to the provision of services. And again, that potentially leads to vulnerability for the seller if the advice to the client's solicitor to the seller, if the advice from the solicitor to their client is defective. And it also means that, again, from a buyer's perspective, are we more capable of relying on the information the seller produced? Are we capable of the seller, given the fact that they've spoken to their solicitor or conveyancer for clarification? And seller solicitor should advise the client in accordance with instructions for the seller. In other words, telling the seller client about the potential warnings on the TA6 form and the potential vulnerability for misrepresentation as a consequence. So all of this, in summary, will have a bearing of how you deal with TA forms in the report on title. And what I would ask you to do in readiness for March 2026 is have a look at the revised TA6 and have a look at how you'd revise what you're saying to a buyer client in your report on title. And remember, the revised TA7 is live and operative, and the revised TA7, in particular with regard to questions concerning the Building Safety Act, has implications both for the seller in providing answers to the questions and the buyer in receipt of the TA7 and the answers to the questions, in particular in Section 11 relating to the Building Safety Act. So we've talked about that, and we've talked about that with regard to sellers revising their retainer, and the buyer's solicitor looking at their report on title and their retainer to make sure the client understands any limitations relating to advice, explanation, or guidance that's given relating to the TA forms and the answers that the seller provides. I repeat what I think is an important practical point. A buyer client should be told in the retainer and indeed in the report on title, you should be using the questions in the TA forms as a checklist, and wherever possible, satisfying yourself as to the answers to those questions by inspecting the property, by making inquiry directly of the seller or third parties. And where information is generated to the buyer via the seller or third parties, given the warning in the TA form, we're going to have to explain to the client what explanation, information, and advice is appropriate, given what the third party or the seller or the seller's lawyer has conveyed to the client. As far as the TA7 is concerned, again, the revised form is now live and operable, and there are questions there that I think no reasonable seller or no reasonable buyer can be left to answer or consider in isolation. I think the seller needs guidance notes as to what these questions are asking about and how they should be answered in general terms, and the buyer should be told that we need to proceed with caution with what the seller is telling us. So, for example, the Law Society guidance on the Building Safety Act says that we should be asking the buyer to confirm the status of the building in which their flat or apartment is located. In other words, are you aware of whether this building is a relevant building or a higher risk building? The buyer is also asked, or should be asked, courtesy of the Law Society guidance to the Building Safety Act, if the buyer is aware of whether or not the building owner has entered into a developer remediation contract with the builder, developer, or owner of the building in which the flat or apartment is located. Now, again, ladies and gentlemen, there's no way that a seller client or a buyer client is going to know the answers to those questions, and therefore we need to be cautious in our retainer and in our report on title that we're dealing with our duty by providing information, explanation, and where appropriate, advice. Again, I repeat the point with regard to advising clients with regard to due diligence and our report on title. We are indicating to the client the existence of risk and suggesting to the client what steps or measures can be taken in order to determine the extent of that risk or to determine the nature of the risk. So, for example, where we're talking about the seller answering questions concerning remediation work for relevant defects, I don't think we can expect a seller to provide us with meaning information relating to those questions that a buyer can safely rely upon. So what we'll be saying to the buyer is the seller has said yes or no with regard to knowledge concerning relevant defects or remediation work or whatever, but say to the client it might be prudent for a surveyor, building surveyor or fire safety surveyor to have a look at the property to determine whether the seller is in fact providing correct information. So I think to an extent we should do what we've always done with regard to advising buyer clients in connection with TA forms, but I think there's an additional gloss or the need for additional information to be provided to the client. On this slide, I refer to two cases that I think are really important for you to look at when acting for sellers or acting for buyers with regard to TA forms, namely the case of Rosser against Pacifico, which I mentioned earlier, and the more recent case of Mr. Woodward Fisher, Mr. and Mrs. Woodward Fisher, who were sued in connection with what was in essence fraudulent replies to additional inquiries concerning the existence of vermin or the existence of an infestation in a very expensive property that was sold in London for £35 million, when in fact the seller was aware that the property was infested with clothes moths. But when asked questions in additional inquiries concerning infestation or vermin in the property, decided, having looked at a dictionary definition and having sought advice from solicitors, that clothes moths weren't vermin, and the existence of clothes moths in the property was not an infestation. Both of those responses were in fact held to be incorrect, leading to a claim by the buyers for misrepresentation, compelling ultimately Mr. and Mrs. Woodward Fisher to buy the property back from the buyers and to pay them compensation and to pay their legal costs. So again, I think this is the important extraction that both a seller and a buyer solicitor or conveyancer need to be aware of when dealing with the TA forms, the current TA7 and the current TA6, and in particular, the revised TA6. So I've covered off that and covered off that and that. Okay, I think a buyer acting in connection with a Building Safety Act related property, in other words, a property within a relevant building or a high risk building, should ask additional questions of the seller. So I think even the revised TA7 form is not adequate to deal with Building Safety Act related issues. And therefore a buyer properly advised should be asked to raise additional inquiries of the seller. And on this slide, I've listed what would be appropriate additional inquiries to be generated. Lessons from case law, we just skipped through, we needn't worry ourselves about that. These were cases that I extracted in connection with a recent webinar I did in connection with the revised TA6 form. So we needn't worry about that. I've also given you details about Rosser and Pacifico, and the call to action here is acting for the seller, as per the slide, and acting for the buyer. Warn clients about relying on replies, explain the potential for misrepresentation, ask the buyer if you'd like to raise any additional inquiries, and report on the replies from the seller and any omissions or outstanding issues or anything that's reported to you by your buyer client. So again, there is some revision to the report on title for most firms, given what we've seen with regard to recent case law concerning misrepresentation and the revisions to the TA6 and TA7 form and the intended revisions with regard to the revised TA6, which came out on the 13th of October 2025. So again, important issues: explain to the buyer the significance and importance of inspection, and recommend to buyer clients as part of the due diligence process that they obtain a survey or valuation. Again, remember what I said last time, the importance and significance of the RICS Consumer Guide to Survey and Valuation, and the fact that you should be recommending to a client in the report on title and in the retainer that the client obtains a level 3 survey. So again, for completeness, in the retainer, you should advise the client about the principle of caveat emptor and recommend to the client that they read the RICS Consumer Guide to Survey and Valuation and that you recommend a level 3 survey. And in the report on title, where the client has obtained a survey or valuation, again, where the survey or valuation is not level 3, I would say to the client or reiterate to the client that you recommended a level 3 survey, but the client has, for whatever reason, obtained a survey level 2 or a valuation or whatever it might be, and explain there's some vulnerability as a consequence of that. Also, in the report on title, you are obliged to read the survey or valuation if it's made available to you and indicate to the clients any issues relevant to title that the surveyor or valuer discloses. Again, remember your duty to report to the client anything that's materially adverse to the interest of the client. If you've read the survey or valuation and there's anything else in the survey or valuation that would be or could be materially adverse to the interest of the client, I think it would be prudent to report that in the report on title as well. Having said that, your duty is simply to include in the report on title issues relating to title or issues that the surveyor or valuer draws to your attention requiring your attention or consideration. So we've talked about that and talked about that, and we've talked about those cases, so we can skip that. And what I want to do now, if I can, is just move along swiftly because I'm conscious of time, and to have a look at this point. If there are gaps or omissions in the TA forms, this should be drawn to the buyer's client's attention. So where the seller has answered a question, I don't know, or where the seller has answered a question, not known, are you aware of Japanese knotweed on the property? The stock answer there has to be from any sensible seller, I don't know. You draw that to the buyer's attention and say, the TA form has asked the seller to provide information about Japanese knotweed. The seller has advised that they're not aware of it, or they don't know whether it's Japanese knotweed or not. Given the invasive nature of Japanese knotweed, it might be prudent to have an expert to provide a report relating to the state and condition of the garden, or something of that nature, indicating to the client the potential for risk and the steps or measures that can be taken to eradicate or mitigate against that risk. So we've talked about those issues. We needn't worry ourselves with those. Let's move on. I want now just to reiterate what I said earlier about essential searches and transaction-specific searches. Again, clients need to be aware of the fact you're using a search company. It may be prudent to explain in the retainer what the result or the consequence of using a search company is, and perhaps indicating to the client where a search is defective, the fact that there is the potential to recover loss courtesy of the search company's indemnity cover, or the source of the information which the search provider is generating. So local land charges, Department of Local Authority, or land registry, dependent on who's produced the local land charges search. Remember, local land charges are overriding interests. So if there is a local land charge that exists, it's binding on your client, but your client can claim compensation. So again, that might be something that you draw to the client's attention in the retainer, or draw to the client's attention where you're reporting on a local land charges search, for example. Your role without, where you have a client who is saying, I don't want searches, or I can't wait for search results to come in, talk to Robert and his colleagues at Stewart Title about no search indemnity cover or delayed search indemnity cover, but do explain to the clients the fact that this cover is in essence protection, but the client could still be bound by search results, or search results revealing adverse entries could have an impact on marketability or viability with regard to remortgage or sale in the future. Client inspection should be dealt with as part of due diligence. And this is an important point that I wanted to get over today. Everyone will tell clients about the importance of inspecting property, but you need to tell the client what a pre-exchange inspection involves. Identification of state and condition of the property to avoid caveat emptor. To identify the physical extent of the property. So is what the client sees where they inspect consistent with how the property is described and consistent with title plan. Again, providing the client with a copy of, say, agent's particulars, how the property is described in the contract, how the property is described in the contract, and survey or valuation, and ask the client to confirm, is what you see when you inspect consistent with all of that information and documentation, and is all of that information and documentation consistent with one another? Pre-exchange inspection should also check the accuracy of the seller's information in the TA forms. And someone just said to me this morning about this question, well, if the client is inspecting, does that mean that the client weakens his case for misrepresentation if there is a defect in the answer to a question in a TA form? And the answer to that question is that the courts have been pretty relaxed about what the bar is to establish inducement. As long as you can prove that a defective response in a TA form partly contributed to the client's decision to proceed with the purchase, that would seem to be enough to establish inducement to enable a claim for misrepresentation to follow. And warn the client about the potential for overriding interests, prescriptive easements, tenancies or leases with a term of less than 3 years, persons in occupation of the property other than the sellers. So you need to tell the client about the need to inspect, and importantly, the client then needs to report to you what they see in inspection. And again, in the report on title, have a section saying, I advised you to inspect the property to look out for the following. You've advised me that you've inspected the property and told me that your inspection did not reveal anything of concern. Or where the client has inspected and has spotted or identified something, I would then say, you have reported to me X, Y, and Z, and as a consequence, I've raised additional inquiries of the seller's solicitors, and this is the result. Clients need to be told, with regard to inspection, they're bound by anything that they actually see and bound by anything that they ought to see, courtesy of a reasonable inspection, the doctrine of constructive notice. And they're also bound by anything that a third party sees, if that third party is inspecting the client, inspecting for the client and on the client's behalf. So the client needs to understand the significance and importance of client inspection, and you need to be reporting to the client what the client has generated as a consequence of their inspection. Same thing with regard to survey and valuation. And again, sorry to bleat on, but I do refer to the RICS Consumer Guide and the need to recommend a level 3 survey. If we're reporting on due diligence, we're looking to report on title. We highlight client objective. We identify all the issues and risks and all issues that are materially adverse to the interests of the client that due diligence has generated. We provide a summary. In the summary, given your objective, this is what we think are important issues that due diligence reveals, but then indicate everything in our report on title carries equal weight and should be carefully considered by you. Next thing, a very interesting and moot point for discussion. Templates, electronic reports that providers are sort of throwing at you with gay abandon at the moment are really useful. If they're made available to you, compare and contrast with what you're currently using them. And I think any form of electronic report or template is a useful aid for you in that it may enable you to spot something or remind you to look out for something that you wouldn't normally or ordinarily look at. And certainly artificial intelligence is gathering pace and enabling us to produce reports on title. However, artificial intelligence is not a replacement to sound, appropriate due diligence and your ability to effectively communicate findings of due diligence to the client. So although I would say use AI, use it sparingly and carefully. Just as you'd use a precedent, anything that AI generates needs to be checked by you in order to confirm accuracy. AI can and does hallucinate, and hallucination can lead to misinformation, and that is generating at the moment professional misconduct issues, both for barristers and indeed solicitors and indeed conveyancers. So be careful about its use. I like the idea of interim reports on title, feeding the client information as the due diligence process continues. So contract pack comes in, interim report on what the contract pack reveals, dealing with TA forms, dealing with the contract, dealing with the title that's produced. Searches are undertaken, search results come in, interim report provided, interim report with regard to survey, interim report flowing from client inspection, report on title dealing with mortgage offer, dealing with co-ownership issues, etc. I think drip feeding the client as due diligence progresses does two things. One, it means you're providing clients with information as it arises. So if there's something that's potentially a deal breaker or a major problem for the client, they're aware of it straight away, number one. Number two, it gives you time to undertake further investigation, to allow the client to undertake further investigation or to consider their position, or for a third party to perform that task for you. Three, it means that as we're progressing towards the time where we're going to ask the client for authority to exchange contracts, the last interim report is not going to be a 70-page or 90-page diatribe about everything that's been investigated, but is simply an update reminding the client about what has been revealed since the second interim report has been produced. In a leasehold transaction, I would produce a separate report relating to the lease itself. Conclusions then, do the simple things well. Make sure that you are effectively communicating with client. So if I'm sending the retainer or the report on title out to the client, Mr. Client, I'm going to ask you to confirm receipt of this document. I'm going to ask you to confirm to me you've read it and understood it. If I'm acting for co-owners, I want each client, each co-owner to confirm all of those stages. I'm going to ask my client, do you have any questions or queries as a consequence of the due diligence I've performed and what I've reported to you? I would explain to the client the importance of the report and the fact that in due course, I'm going to ask the client for authority to exchange contracts with all that that entails. With regard to reporting on defective title insurance policies, as Mr. Robert Kelly is gracefully able to announce to practitioners, one, explain to the clients that defective title is a solution, but not necessarily the only solution and not necessarily the solution. That the defect in title still exists and could be problematical at some point in the future. That the client owes duties and obligations to the insurer that are ongoing. That a failure to notify the insurer of emails, correspondence, claims, or any information relating to the risk of the policy could invalidate the policy. And disclosure of the existence of risk or the disclosure of the existence of a policy to a third party could also invalidate it. So with regard to due diligence, ladies and gentlemen, there are lots and lots of things that need to be carefully explained to the client. That, ladies and gentlemen, concludes the formal part of my presentation. What I'm going to ask now is just quickly if anyone has any questions. In the slides and in the notes, I've looked at leasehold due diligence and reporting on title. Don't have time to deal with it today. Perhaps that's something we can look at when we talk about dealing with leasehold transactions. But I'm now going to have a look at the chat and see if there are any questions or any comments in the chat. We'll have a look at the questions and then we'll finish. So chat, nothing other than I'm hoping everyone can hear me apart from the glitch where we lost communication briefly. And as far as questions are concerned, Mr. Robert Kelly, I don't appear to have any questions in the question box on my slide or on my desktop. Does anyone have any questions or queries? Hopefully what I've said has been of use. Robert, anything to add?
No, thank you, Ian, for a very interesting talk. It just shows how complicated things are getting now and how much more you need to do.
Without a doubt. Yeah. I mean, I think the problem is, Robert, that people look at their report on title, it's done. It should be constantly reviewed and revised. So it should have been revised when the Law Society guidance on climate change came out. Was it in June? And I think we now need to have a look at it with regard to the TA6 and the revised TA6, because it changes, I think, the relationship between the seller and the seller's conveyancer, and means that the seller's conveyancer and solicitor is more involved in the provision of replies. And it also involves or highlights or indicates to both the seller and buyer that the buyer could be getting information from sources other than the TA form. And that means that if I'm acting for the buyer, I'm going to have to deal with whatever the buyer becomes aware of in my report on title. Or alternatively, in the report, say I'm not going to be advising or reporting on anything that's been disclosed to you that hasn't been disclosed to me. I think that is perhaps the other way of dealing with it. So one last opportunity. Does anyone have any questions? Again, Robert, I don't think I've anything got in the question section of my.
No, I can't see any either. But I think
So
that's just
that means either Robert sent everyone to sleep, or more accurately, I've sent everyone to sleep, or I've provided them with all the information that they require. I can't think for the life of me the latter applies. I'm rather concerned that the former may apply. What I would say is that the number of attendees seems to have been fairly constant, which gives me some comfort that we've been of use. Robert, on behalf of myself and all attendees, a massive thank you to you and Stewart Title for organising these events. Once again, you know, not wishing to blow my own trumpet, but by the number of people that have attended, I would say that of itself is a resounding success. If anyone has any issues, questions, or concerns about defective title insurance, you've got the main man, Mr. Robert Kelly, available to you. His contact details were provided, I think, on slide number 3. And you've got the business development team and underwriters at Stewart Title that are able to assist. Even if you've got another provider with regard to title indemnity insurance, do talk to Robert and his colleagues. They have some unique offerings and they have specialism and expertise that I think you and your team and your colleagues can utilize and call upon. And I think once you've done that, you'll be very impressed with what Robert and the team have to offer. Ladies and gentlemen, I know that you're dying to get back to your desks and or looking after the children, given it's half term. So 1,000 apologies for running over. I hope that's been of use. If you'd like topics that to be discussed in future CPD events, let Robert or myself know, and we'll see what we can do. And in the meantime, thank you very much. If you have any questions of me, feel free to drop me a note by email and I'll endeavour to answer them. Robert, as ever, thank you for your assistance and your technical ability in managing the webinar, and thank you for everyone else for attending. Safe journey home if you're going home or travelling home this evening, and thanks very much for coming along. Cheers, Robert. Thanks, everyone. Take care and stay safe. Bye-bye.